right, good afternoon, everyone. Hopefully everyone can hear me. I think we have a sufficient audience to get going. We appreciate you joining us. Welcome to Civil Disagreements, a discussion about elimination of the Chevron doctrine. My name is Steve Davis. I'm a member of the American Bar Association's Standing Committee on Public Education. The mission of the Committee on Public Education is to advance public understanding of law. And our topic for today's discussion is power, liberty, and regulation after Chevron. This is the latest in a series of moderated discussions on current, critical, and often contentious civic questions co-sponsored by the American Bar Association's Division for Public Education, the Chicago chapter of the American Constitution Society, the Chicago chapter of the Federalist Society, and Reform for Illinois. Today's program will feature a moderated panel discussion, as well as an opportunity for your questions, audience questions. Please share any questions you have using the Q&A function. And you also might want to keep an eye on the chat where some materials, supporting materials, background materials, links to those will be posted in the chat. As a bonus, for any Illinois lawyers joining us, you may receive CLE credit for this program. Simply watch for a follow-up email tomorrow with instructions on how to claim that credit. So to begin, just to summarize, in 2024, the U.S. Supreme Court issued a decision in a case concerning the administrative state and interpretation of statutes. The statutes that are administered by federal agency. The case is Loper Bright versus Raimondo. And the case struck down a long-standing legal principle known as the Chevron doctrine. As you may have guessed, we get the name Chevron doctrine from a Supreme Court case called Chevron. It's a 1984 case entitled Chevron USA Inc. versus Natural Resources Defense Council Inc. So in that case, the Supreme Court unanimously held that when an administrative agency reasonably interprets an ambiguous term in a statute, a reviewing court must defer to that agency's reasonable interpretation. So in Chevron, it regarded the Clean Air Act. The Clean Air Act required states who had not achieved a certain kind of air quality standard to establish a pollution permitting system that regulated the amount of pollution emitted from factories and other places. The permitting system was to regulate what Congress put in the statute. Congress called stationary sources of air pollution. And stationary sources were generally interpreted as a place that emits air pollution, like an industrial manufacturing plant. The EPA, it was an open and ambiguous term, what stationary sources meant. So the EPA defined the term in a way that some environmental groups disagreed with. So they sued, and the lower court in Chevron threw out the EPA's regulations as inappropriate for a program enacted to improve air quality. And so in that case, the Supreme Court reversed and said that a court is to follow two steps in reviewing an agency's interpretation of statutes. Step one, courts ask whether Congress has directly spoken to the precise question at issue. And if the intent of Congress is clear, that's the end of the matter for the court, as well as the agency. And the court must give effect to the unambiguously expressed intent of Congress. But If a court decides that the statute is ambiguous, as with stationary sources, the court must defer to the agency's interpretation, so long as that interpretation is a permissible construction of the statute. So fast forward to last year. This has been a controversial topic, whether courts should defer to agency interpretations and what is the role of courts in interpreting statutes administered by agencies. So last year in Loper Bright, the Supreme Court took up this issue again of whether courts must defer to an agency's interpretation of ambiguous terms in statute. And in Loper Bright, it's kind of interesting case. It involved the Magnuson-Stevens Fishery Conservation and Management Act. So you can imagine that might be a complicated act, including some ambiguous terms. It authorized the National Marine Fisheries Service, which I didn't know existed until this case. It authorized that service to require certain fishing vessels to carry on board a federal observer. But the act did not specify who must pay for the federal observers to be aboard the fishing vessels to monitor whether they're following the law. The agency adopted a regulation requiring fishing vessels to pay for the cost of observers. So that seems typical that the government would say, well, the person being regulated must bear the cost. The fisheries sued, arguing that the act did not authorize the agency to adopt this regulation. So the Supreme Court held in a landmark case that the Administrative Procedure Act requires courts to exercise their independent judgment in deciding whether an agency has acted within its statutory authority, and courts may not defer to an agency interpretation of the law simply because the statute is ambiguous. And the Supreme Court said Chevron is overruled. So we're going to explore what this decision might mean, what questions it leaves unanswered, and how it might affect our world going forward. So I'm going to moderate today's discussion and turn over the discussion to where it belongs with our three panelists who are eminent scholars in administrative law. I will go ahead and introduce them in the order in which they will give an opening statement. We first have Professor Vikram Amar. Professor Vic Amar returned, he's at UC Davis as a distinguished professor of law. He returned there in 2023 after serving as the Dean and Professor of Law at the University of Illinois, Urbana-Champaign. He also taught law at Berkeley and Hastings and the UCLA Law School. Professor Amar is one of the most eminent and frequently cited authorities in constitutional law, federal courts, and civil procedure. He's produced several books and more than 60 articles in leading law reviews. He is the co-author, along with his brother, Akhil Amar, professor at Yale, of the upcoming revised multi-volume treatise on constitutional law. I wasn't aware of this until today. This is exciting. The treatise pioneered by Ron Rotunda and John Nowak that I used in law school. He's also the author of a well-known casebook on constitutional law and a co-author on multiple volumes of Wright and Miller, Federal Practice and Procedure, which I use all the time. He writes a bi-weekly column on constitutional matters for justicia.com. He's a frequent commentator on local and national radio and TV. He's an elected member of the American Law Institute and past chair of the Civil Procedure section of the Association of American Law Schools. He earned his bachelor's degree from UC Berkeley, and his JD from Yale. After law school, he clerked for Justice Harry Blackmun of the Supreme Court, and interestingly, he was the first person of South Asian heritage to clerk at the Supreme Court and was the first American-born person of Indian descent to serve as a dean of a major American law school. Second, we'll hear from Will Yateman. Will Yateman is actually my colleague at Pacific Legal Foundation. He is a senior legal fellow there on Pacific Legal's constitutional scholarship team. And his area of expertise is to take the fight of individual liberty to the modern day Leviathan known as the administrative state. So I'll let Will explain that further if he wants to. Will came to the Liberty movement as a result of his Peace Corps service in Central Asia. Will says that upon witnessing firsthand how generations of statist rule can erode the instinct for free markets and individual freedom, he realized liberty must be defended in order for it to flourish. Following his time abroad, he joined the Competitive Enterprise Institute, specializing in environmental policy. While there, he pursued a law degree at Georgetown. And after graduating, he moved to the Cato Institute Center for Constitutional Studies, where he put his legal education to work writing amicus briefs on controversies that involve administrative law doctrine, in addition to researching regulatory reform. Will has testified before Congress and state legislatures many times. He's a frequent contributor to major media outlets. He has published in the Georgetown Law Journal, Cato Supreme Court Review, and Appalachian Natural Resources Law Journal, just to name a few journals. And his popular writing has appeared in the Wall Street Journal, Foreign Policy, and Bloomberg. He holds a BA in Environmental Studies from the University of Virginia, a Master's in International Studies from Denver University, and a JD from Georgetown. And our third panelist, Professor Daniel Rodriguez. He is the Harold Washington Professor of Law at Northwestern University Law School. He served as Dean of the law school from 2012 to 2018. His principal academic work is in the area of administrative law, local government law, statutory interpretation, federal and state constitutional law, and the law-business technology interface. Formerly, Professor Rodriguez served as a law professor at UT Austin. He served as Dean and Professor of Law at the University of San Diego Law School, and as a law professor, and I just lost, visiting professor at other top law schools, including Stanford, Harvard, Columbia, USC, and Virginia. He received his law degree with honors from Harvard. So hopefully we'll have maybe a little bit of a battle between him and Professor Amar. And his undergraduate degree from California State University of Long Beach. So I know those intros were lengthy. It's because these scholars are so preeminent. I actually cut them down quite a bit. They've accomplished so much. So we're very fortunate to have these three panelists explain the Loper Bright decision and its consequences and the Chevron doctrine. I'm going to turn it over to each of them to give an opening statement or explanation, whatever they'd like to say, for about 10 minutes each. And then we will have some comment and questions. So I'll turn it over to Professor Amar.
Thank you so much, Steve. And thanks also to the organizers and attendees of today's event. It's my honor to be here with Will and Dan and Steve and the rest of you. So as Steve helpfully reminded us, in 1984, the Supreme Court decided this case called Chevron versus Natural Resources Defense Council, NRDC. It's one of the most frequently cited cases in U.S. Supreme Court history. It's a case that maybe a lot of lay people don't know about, but people who work in the area of government regulation and administrative law definitely confront Chevron all the time. And as Steve pointed out, the question in Chevron was a somewhat technical one about the meaning of a term in the Clean Air Act, namely a stationary source. Does a stationary source refer to a factory that emits pollution, or to each smokestack in that factory that emits air pollution? And the Supreme Court, by a unanimous ruling, is one thing interesting to note, that Chevron was not a politically contentious decision. It was not a partisan decision. It was unanimous, as Steve pointed out. It's actually Justice Stevens' most frequently cited decision. And we can talk about Justice Stevens in another episode sometime. I think he's a very interesting jurist. But in Chevron, the court said, when a statute has a term in it that's not entirely clear as to its meaning, then and only then do we defer to the agency that has been assigned the power to implement that statute. And as long as the agency's interpretation is reasonable, we defer to it. Now, what does it mean to defer? It means that even if we as a court would have decided that that statutory term means something different than the agency thinks it means, as long as the agency's view of the statute is not outside the realm of the reasonable, then we go with it, even if it's not what we, the courts, would consider the best reading of the statute. But it's important to note that this deference comes into play only if the statute isn't clear in the first place. That's called Chevron step 0. If the statute is clear, then there's no deference afforded at all. And also, we're giving deference to the agency as to the meaning of the statute, but that doesn't necessarily suggest that what the agency did is going to be upheld. It's about the meaning of the statute in particular. Okay. Now, along comes, and I should say that this deference was given under Chevron basically for a couple of different rationales. One is that the agency has expertise in a particular area that it's working, and so we want to respect the agency's deep knowledge, which is sometimes scientific, sometimes it's empirical, and we want to make sure that we're crediting the agency for all all the expertise that it brings. But also, there's a theme in Chevron and cases after Chevron to the effect that because the agency is overseen by a president who is elected by electors who are in turn selected by the people of the United States, that vis-a-vis unelected Article 3 federal courts, agencies are more accountable, and therefore they should be given some deference in applying the meaning of the law, because they're closer to the people whose consent gives the law legitimacy in the first place. So there's an accountability theme, and there's also an expertise theme. All right. By 2024, that had kind of gone away, and Loper Bright, as Steve pointed out, by a 6-3 vote, decides to overrule Chevron and say that it's up to the courts and not the agencies to decide what a statutory term means. Chief Justice Roberts' opinion in Loper Bright quoted actually Marbury versus Madison, of all cases, for the proposition that it is emphatically the province of the judiciary to say what the law is. It's not the province of the executive branch emphatically to say what the law is. Now, emphatically, by the way, doesn't mean exclusively, but it means especially. So courts are especially trained in giving meaning to the law. So under the Administrative Procedure Act, which is the kind of the framework statute that under which judicial review of federal agency action is usually obtained, under that statute, Roberts said, there's no indication that Congress intended to give interpretive power to the agencies rather than to the courts, where it would naturally reside. So Chevron deference is no more. Courts, rather than agencies, decide what the statute means. Even if the statute is ambiguous, courts give that statute the best meaning that it can come up with, notwithstanding what the agency thinks the statute means. Loper Bright is an important case, but it's not, I think, necessarily kind of a world-changing case. It's somewhere between significant and kind of a path breaking. And here's why my view is that it's a significant ruling to be sure, but it's not one like, say, Dobbs or Heller, that overturned earlier cases involving abortion and gun control rights, for example. First of all, to say that agencies no longer get deference as to the meaning of a statute is not to say that agencies don't get deference in other ways. And the court in Loper Bright was clear that we still defer to an agency's expertise on questions such as, will a particular regulation help solve a particular problem that Congress clearly wanted to solve? Or does the world operate in a particular way such that we need to know what those underlying background operational facts are before we decide whether an agency's regulation is permissible or not. So when it comes to scientific questions and real world empirical questions, the agency may still be deferred to, but they're not deferred to on the legalistic question as to the meaning of a statute, the interpretation of a statute. Second, remember I said a few moments ago that Chevron comes into play only if the statute is ambiguous. And a lot of courts had been increasingly determining that statutes weren't ambiguous, so they didn't even have to deal with the Chevron deference in the first place. That was especially true in the U.S. Supreme Court. The U.S. Supreme Court had not cited Chevron favorably very frequently in a lot of years, so that people kind of knew the writing was on the wall. Chevron had and has and Loper Bright therefore has more implications in the lower courts, where the lower courts were citing Chevron to some extent, and now they're not going to be relying on that. But because the Chevron framework was flexible to begin with and depended on a determination that the statute was ambiguous, I think a lot of lower courts that didn't like Chevron could get around it anyway. So the fact that they're citing it less now, I don't know that that necessarily means that they are actually relying on Chevron less than they used to. They may not have been relying on it that much even before. It's a hard empirical question to answer because you don't know how often courts cite a case without really making use of it, but it's rather instead it's just window dressing. So third point is that the court did not say that Congress could never give agencies a role to play in interpreting statutes. They just said as a default matter, statutes don't do that under the Administrative Procedures Act. So if Congress wants to go back and overrule Loper Bright in narrow or broader ways, that remains a possibility. Fourth, the court did not disturb any agency action or regulation that had already been litigated under the Chevron framework. So if an agency's action had been upheld under Chevron in the past, that agency action is still upheld today. So it was not a case that tried to have a lot of retroactive applicability. So these are all ways in which I think it is important but limited. Now, I think in some ways its significance really relates to the way in which it fits into a broader theme. And here's where I'll leave off. So the concern about unbridled administrative power, jackbooted thugs in the executive branch running amok, is reflected in not just technical doctrines like Chevron, but in a lot of other things that the court in the last 3 or 4 years has been doing. So, for example, the major questions doctrine that was used to strike down Joe Biden's effort to forgive student loans. Or the major questions doctrine that was invoked by the 3-judge panel of the Court in International Trade to say last week that the IEPA, the International Emergency Powers Act, Economic Powers Act, does not give the president broad-ranging powers to impose tariffs anytime he wants. This doctrine says where major policy questions or a lot of money or individual rights are at stake, we're not going to construe a statute as giving the president broad powers unless the statute does so explicitly. So the major questions doctrine, the non-delegation doctrine, which is a notion that we should be careful before Congress gives too much power to the executive branch, these are all part of the same pullbacks of broad executive authority that Loper Bright is. There was another case last term called Corner Post, where the Supreme Court said that if you're going to challenge an agency regulation on its face, you have to do so within 6 years of its promulgation. You can't wait until it's applied to you. You can still challenge it as applied to you when it is after that period, but if you're going to challenge it on its face, you got to do so within a narrower timeline. That will reduce the ability of people to challenge certain decisions by agencies. Um, so if you look at this in a larger context, it represents a constitutional discomfort with broad executive powers absent explicit congressional authorization. And I think, by the way, and this is where I'll leave off, two points. One, I wrote in one of my first pre-tenure articles that Chevron really doesn't fit comfortably with separation of powers to begin with. And here's why. Because an agency headed by a president might have an incentive to construe statutory terms broadly so as to confer power on the agency. So it has an incentive to read these words in a way that enhances executive power. But if Congress wants to override that interpretation under Chevron, as long as it's a reasonable one, Congress might need 2/3 of the House and 2/3 of the Senate to overturn that. So a simple majority of Congress plus one and the president, they enact a statute that creates certain terms. The president uses those terms to aggrandize his power, and Congress never wanted that. And what took a simple majority of Congress to create takes a supermajority of Congress to reclaim, because the president wears two hats. He both gets to enjoy the exercise of the power, and he gets to have a say in efforts to reclaim that power because of his veto. So I thought this is in a lot of tension with the non-delegation doctrine, and I think that's kind of part of where the court is going these days. I think the direction is a good one. I'm a little saddened that the conservatives who are pushing that direction were the same conservatives who were supportive of Chevron in the 80s when Reagan and Bush were in the White House. I mean, after all, it's the Sam Alitos and the John Roberts who were the architects of the Chevron edifice. So I don't like the inconsistency, but fine. They've seen the light. I'm glad about that. I hope that they are consistent in applying some of these new doctrines to rein in broad executive power unauthorized by Congress over the next 4 years, as they did over the last 4 years. And with that, I'll turn it back to you, Steve.
All right. Thank you. Thank you, Professor Amar. Very good points and a great explanation of the nuances and meaning of the case. Next, I turn it over to Will Yateman. Will, please go ahead and share your thoughts.
Oh, indeed. Thank you, Steve. And yeah, indeed, that was great stuff, Vic. And I actually want to pick up a thread that where you ended with that separation of powers discussion, which I 100% concur, and I also 100% agree. God willing, the Supreme Court, just as you said, this is we're seeing a lot of doctrinal responses to what I would say is a constitutionally unhealthy growth in executive power over the last couple decades or so. So in that vein, I want to sort of describe further why I welcome Loper Bright and why I think Chevron deference was inimical to our constitutional system. And here I'm going to start with first principles. Literally, I'm going to start with the definition of deference. So I took to two dictionaries and I found two what I think are apt definitions for deference. Obsequious respect, and then respectful submission to another's judgment. All right, so that's deference defined. Now, keeping with first principles, deference to what? What receives this obsequious respect from the courts, or what used to, under the guise of Chevron deference? And as Steve set forth at the outset, in legalese, courts defer to agency interpretations of ambiguities in the regulatory statutes that they administer. All right. Well, in practical terms, courts are deferring to agency interpretations of their own power. That's synonymous with that rubric that I just set forth for what's at stake. Okay, well, let's put it all together. So deference entails judges giving obsequious respect to agency readings of their own authority. And I think the conceptual constitutional problem ought to be self-evident. The founding fathers were very sensitive to the concentrations of power. In Federalist 47, Madison, quoting Montesquieu, no less an authority, quote, "There can be no liberty if power of judging not be separated from the executive power." And indeed, this is the sort of thinking that animates our entire constitutional structure. Again, this combination of the authority, the function, the legal exposition function, with that of the legal implementation, laws implementation, engenders tensions with our constitutional design. All right. 1984, as both Steve and Vic set forth, Supreme Court institutes the Chevron principle, deference. I just described it. All right. From a separation of powers standpoint, Chevron couldn't have come at a worse time. And why? As Chevron came online in the 80s and 90s, Congress was going offline. So what am I talking about here? Congress receded. We see it today. Congress today is a shell of its former self. And that process really began in the late 80s, early 90s. And alas, it continues today. All right. So Chevron comes along. As Congress recedes, the executive fills the vacuum. It's in this context, and at this point, when an independent judiciary becomes crucial. However, instead of that sort of that line of jurisprudence, we get deference, this obsequious respect. So it was the combination of these two factors, among others, to be sure, but that have led to what Vic said, and I agree with, executive power running amok, sort of brimming at the seams. Wait a second. Oh yeah. So I mean, simply put, the way our system is designed is that competing branches of government check one another. I mean, and that safeguards our liberty. So what we saw during the Chevron era was Congress not competing with the executive, and courts ceding legal exposition to the executive, deferring. This is unhealthy. And again, this led to a gross imbalance, a constitutionally unhealthy imbalance in our separated powers. And it's really for this reason, it's for this reason that I support Loper Bright. Now, I'll note something here regarding the effect, the consequence of Loper Bright. I agree with Vic. I mean, it's not as big a deal as Dobbs. I mean, that's the end all. That's a big deal. But I think it's closer to Dobbs than perhaps Vic might. As he had noted, the Supreme Court had largely abandoned the Chevron framework over the last 6 or 7 years, but it proceeded apace in the lower courts. And what developed there is what Justice Kennedy called reflexive deference, what Judge Walker on the DC Circuit called a Chevron maximalism, but it was this habit of lower courts skipping straight to deference without that crucial statutory analysis that Vic talked about, Steve talked about. That's step one of Chevron. With Loper Bright, it's a pretty darn clear signal from the court to cut that out. And I do think that will have a large effect on administrative law. And to this end, I agree with Vic 100%. It's an empirical matter. And as of now, there aren't that many numerical points, data points out there. But there is one, and they'll share it with you because I think it's eye-opening. Bloomberg Law, about 5 months after Loper Bright came out, rounded up cases of statutory interpretation that formerly would have been analyzed or before would have been addressed by courts under the Chevron framework. And what they found, let me get the numbers. So 22 of the 26 post-Loper statutory interpretation cases went against the government. That's remarkable. And again, as Vic said, I 100% agree. These stats, empirics here are tough. We're dealing in the social sciences. This is not physics. These numbers aren't God's truth. However, that is a striking indication that after Loper Bright, we are seeing the lower courts catch up to the Supreme Court and really perform that analysis that Vic set forth, the crucial one, the analysis that Steve set forth when he was discussing Chevron step 1, this investigation into the statute for a best meaning. So that, in short, is why I welcome Loper Bright and why I do think it's a big deal. Thank you.
All right, thank you, Will. Great response. And before I turn it over to Professor Rodriguez, I just want to remind everyone some great links are being put in the chat to materials including an article of Professor Amar's, I see. We'll turn it over to our final panelist, Professor Rodriguez. Take it away, Professor.
Thanks, Steve. I'm glad to be with you, and I hope in the spirit of the program that's been called Civil Disagreements, we can forward some disagreements. I will certainly try to. Frankly, I'm glad that we're not part of a drinking game where we have to take a drink whenever the phrase "I agree with Vic" has been made, because we barely make it through the panel. So would that Will would say I agree with Dan as many times. He also invoked God. He said God willing. So I'm both against Vic and God and Will in order to provide some pushback. But I'll nonetheless try provide some pushback. Before I do this, let me say, in the spirit of the kumbaya moment with Vic, say I agree with Vic in his declaration that Loper Bright may not be as bombshell as it may appear. I read his analysis to say it's too soon to tell, but the bullet points at the end where he describes some ways in which the demise of obsequious deference, I like that, obsequious respect, had already been portended by the way that the courts had been treating Chevron in the last few years, along with stare decisis and the point about deference, and a key point that it risks us getting too much in the weeds about administrative law. So let's, for the most part, stay out of the weeds, but let me dip my toe in a little bit to say the deference to administrative agency decision-making animates much of administrative law, much to the chagrin, I suspect, of Will. But it persists in how we read the APA. The standard of review for most administrative agency decisions that do not involve interpretation, primarily as a focal point, the interpretation of the statutes, is under the rubric of something called arbitrary and capricious review. Just let those words settle in your head for a moment. An agency decision will be upheld as long as it's not arbitrary and capricious. So the fix is in, as it were. And let me start there with some pushback. Will, I think to a less extent Vic, although both are perfectly capable of speaking for themselves rather than having me interpret what they say. But let me push back hard against the premise underlying the welcoming and the embrace of the kind of anti-administrativism that animates not only Loper Bright, but, as Vic reminded us, a number of key doctrines that are swirling around in modern administrative law in the courts. The rise of the major questions doctrine, which is a remarkable doctrine, and let me say one fairly recent in origin, dates back less than a decade in some key decisions. The looming threat that statutes will be invalidated under the non-delegation doctrine. For those who are not part of the cognoscenti of administrative law, let me say that hasn't happened since the New Deal, since the 1930s. It's been almost 100 years since the Supreme Court has struck down a statute under the non-delegation doctrine. But conservatives, and particularly libertarians, are licking their chops, as it were, with every expectation that the non-delegation doctrine may, like the zombie doctrine that it is, rise to fight another day, and other aspects of that. But all of those that on the kind of the FedSoc wish list is built on an edifice that has strong negativity, skepticism about administrative power. And the rise of administrative power is not something that began in the 1980s when Will talks about the recession of the key role of Congress. I don't know why arbitrarily you start with the 1980s. The strong delegations to administrative agencies date back more than 100 years. It was in the 19-teens that Congress created power to the Federal Trade Commission that gave the FTC a remarkable authority to legislate, here I'm going to use my air quotes, unfair trade practices. It was in the 1930s that Congress accorded deference to a whole range of administrative agencies, the Federal Communications Commission, to implement just and reasonable rates, the Securities and Exchange Commission the National Labor Relations Board to police unfair labor practices. And indeed, it's in the 1880s that Congress accorded, in its first major federal regulatory intervention, power given to the Interstate Commerce Commission to prescribe just and reasonable rates. So the barn door has long been open to broad granting of administrative power, not unlimited. The fact that we have an Administrative Procedure Act suggests that from the time of the key advent of the administrative state, roughly around the New Deal, we had every expectation that all branches of government, the executive branch, the legislative branch, certainly the courts, and also the agencies themselves, through obligations that they had to follow certain administrative procedures, would provide the kinds of checks and balances on administrative agency action. Now, I'm not naive, and those checks and balances have been imperfect. And there has been what a scholar a number of years ago called the rise and rise of the administrative state. And there's an equilibrium that may well be out of balance, and a number of judicial decisions, but also actions of Congress, the receding Congress, as Will describes it, actions of Congress through statutes that you really have to be a nerd, administrative law nerd, to really embrace and contemplate. The Unfunded Mandates Reform Act, the Congressional Review Act, and a number of other statutes have been enacted over the years precisely in order to not rein in administrative agencies. I would think that's a bit hyperbolic, but to provide some additional checks. Which brings me to the modern day. Certainly many of the efforts underway in the Trump administration, let's call it President Trump 2.0, is an effort not necessarily in one linear way to roll back administrative agency action. Although, to be quite clear about it, executive orders and other statements suggest that there is an ambition and an objective to curtail many of the actions of administrative agencies, on the theory that the American people have, the majority have, voted for some regulatory adjustments. But at the same time, under the rubric of the Trump administration, there's been some efforts to change existing administrative regulations. And let me bring this conversation back to Loper Bright. It will be much more difficult, ceteris paribus, as economists like to say, it will be much more difficult for the Trump administration to roll back administrative regulations and exercise broad executive power to do so, if essentially what is put in place, again, hearkening to the wish list of many conservatives, is very strong judicial power. And so I want to really, with respect and civility, disagree with one premise of Will's argument. In what he says is the way in which now the courts are coming to the, I'm going to paraphrase, of course, coming to the rescue, riding in to curtail administrative agencies that have gotten out of whack, broad executive power that have gotten out of whack, and all of that. Justice Sotomayor, in another case from the last term, not Loper Bright, made the rather, extraordinary comment that a lot of these administrative agency decisions that the Supreme Court decided, SEC versus Jarkissi, the Corner Post decision that has been made, others, are judicial power grabs. It's not zero sum. I'm sorry, let me rephrase that. It is zero sum in some way. The replacement and the supplanting of strong administrative power, which quite understandably has been a boogeyman, as it were, of conservatives and libertarians for many, many years, I think, again, understandably so, is being replaced by a very strong assertion of judicial power. Loper Bright is quite conspicuous about that in saying that statutory interpretation is for courts to decide. Marbury versus Madison says it is the exclusive duty and province for courts to decide these issues. That redounds to the benefit, as it were, of courts doing interpretations. And courts doing interpretations and having more power comes at the expense of broad administrative power. Now, this is maybe not the time nor the place to double down or triple down on the matter of whether there should be more administrative power and less judicial power. I have my views, and we all have our views. But I'll simply say, as a matter of political science, that Loper Bright, if it does represent a really significant retransformation or transformation of the relationship among the branches of government, is likely to yield more power for the courts. And whether you believe that courts should be entrusted with that kind of power to direct administrative agency decision-making and regulation, I think is not only an empirical question, but a philosophical question. And I think the jury is very much still out about whether that power will be exercised. I'll close because I know we want to broaden this to get more impact by just simply making the point that maybe is tacit in what I've said before is it's certainly too early to tell. Agree with Vic in that regard. But the question of what the new equilibrium will really be a reflection not only on what courts do in the Loper Bright world, but what Congress does by way of reaction, not only in the statute making process, but in the statute supervision process, what the president does, this and future presidents, in the shadow of these kinds of cases, but last but not least, what administrative agencies do. Will they cede power? Will they expand the scope of their power? Will they turn their attention to non-statutory interpretation rubrics in order to implement the power? And that, I think, will be fascinating to witness and watch, and will give us all an opportunity to be critical of what those branches do in the years to come.
Thank you very much, Professor Rodriguez. Appreciate you stirring the pots civilly and bringing promoting some discussion. So I'd like to, while people are thinking of questions and entering those questions in the Q&A function, let me turn back to Mr. Yateman and Professor Amar. I think Professor Amar is wanting to go first to respond to what you each other have said.
Will, if you'd rather jump in, that's fine too. Either way. Okay. Yeah, Dan, I think those are very helpful framing remarks. First of all, I think I misspoke earlier when I said corner post required that you bring the action challenging regulation within the 6 years of its enactment. It's just the opposite. It allows people to challenge regulations for a longer period of time, which again is in keeping with this theme of undermining the stability of what the agencies are doing. Dan, I guess I would say I fully agree with you that broad congressional delegations and loose statutory language certainly goes back to, the New Deal and the decades before it. And I think it's in part a function of the fact that Congress is not institutionally equipped the way the executive branch is to deal with a lot of really complex problems of a much more complicated, knit together national economy. Again, in the mid to late 19th century, when you have kind of an agrarian, localized society, you didn't really confront a lot of problems that required really detailed solutions from on high, whether it's pollution, whether it's child labor, and the like. So it's not surprising that you see more leeway being given to the executive branch beginning in the New Deal. And I think Will's point, which I agree with, is for reasons that I still don't fully understand, Congress has really laid down and not exercised any of the oversight power you closed with at the end about how they're going to react to what agencies are doing and the like since the 80s and picking up steam in the last 10 years. The parties, I don't even really know what the parties stand for anymore. They're just kind of like personality cults. If you both of them are to me. So political scientists can talk about why that's happened. But your last point I think is a really important one, and that is as scared as we are about broad presidential power exercised through agencies, should we also be fearful of broad judicial power through unelected judges? If power is a zero-sum game here, moving the bubble under the rug from the executive branch to the judiciary, does that really redound to our benefit? And I guess what I would say is recent events, and I'm not talking just about the Trump administration, I'm talking about Joe Biden and his obvious physical and mental issues in office. They highlight to me the fear that one should really feel about concentrating power so much in an individual as our Constitution does under the unitary executive. We could debate over how broad the unitary executive theory should cut, but I think everyone has to agree that we do have a form of a unitary executive. And so the kind of congressional kind of acquiescence combined with that broad presidential authority in modern times really, if you're asking me if I have to pick my poison, where do I want to take my risks? I'm not sure that I'm not a little bit more comfortable with courts interpreting these things in the first instance. And again, we're talking about them interpreting the statutory language, not ultimately, in theory at least, riding roughshod over policies that are really better determined by elected branches based on empirical facts that those branches can determine. I guess I would say one other thing, and my biggest fear is actually not that the power vacuum that Loper Bright creates, that where we shift power from the executive branch, if the courts kind of assume that in a way that itself is despotic. My bigger concern is since Congress does nothing and the president is going to be defanged to some extent, that we don't really have the tools to solve any of the existential problems that might confront us, whether it's AI and its threats, whether it's addiction to technology, whether it's climate matters, whether it's demise of democracy. I mean, we face some things now that we never faced before. And if no branch of government is really, we have this Alphonse and Gaston routine where no one is taking responsibility and no one has the real power. I'm not sure we'll be able to make a dent in some of these things, but let me shut up and give it to Will.
I will. Please feel free to respond. A lot in there.
Oh, indeed. Well, a lot. I mean, shoot, I agree. The I guess the drinking game. The comment about courts, with whom are we more comfortable in this context where Congress is doing nothing and executive branch is acting ambitiously? I'll say this: Roscoe Pound, who was a famous administrative law commentator scholar back in the 40s, that was a big point he made, that it's actually courts that have the institutional competence in this context because they have independence, because they have tenure. Sort of along those lines, the fear had been, not the fear, a fear articulated by Dan had been judicial power grab. Well, I mean, again, and this is a matter of perspective, but the way I see it, it's a judicial reaction within our dynamic separation of powers to executive power run amok. I mean, it's less of there's not an initiative on the court's behalf, the least dangerous branch to become robed policymakers. I think the initiative was with the executive branch over the last 40 years, pressing the envelope of its existing statutory power, dusting off the law books and fusing old terms with the most capacious possible meaning at the behest of an executive order. So it's but your point is well taken. Of course, that's the criticism. I mean, we don't want judges. You can't identify where to draw the line. That would be impossible. The nature of our separation of powers is that the lines are hazy, but it's some balance, I'd imagine. It's certainly incorporating this notion of the independent judiciary. There was one other point I wanted to make regarding Dan that I think is the big kahuna. You said it at the tail end, and it was, how are agencies going to react? Are they going to continue apace with what they've been doing, these capacious readings of the statute, the going for broke every administration, and then the next administration doing the opposite, and then going for broke again, and flip-flop? Or will they get the message that the court seems to be sending over and over again in West Virginia v. EPA, that major questions case, and in Loper Bright, stop it? I mean, that is to say that the message that is emanating from the court. I'm an optimist. However, here I've got reasons for pessimism just because of the recent historical record. In the wake of West Virginia v. EPA, neither Biden nor Trump have done anything but throw caution to the wind. And in the wake of Loper, it's been much the same. So will it take another chiding from the courts, or will it take sustained lack of success, like that I mentioned, the empirical data from Bloomberg Law, where the government lost 23 of 26 or something like that in the first 4 months after Loper Bright? I don't know. I'm hopeful eventually the executive branch gets the message. But I do think that's the big, super outstanding question is, how are these agencies going to react? Are they going to rein it in a bit?
One sentence. I know we're short on time, so I promise one sentence. The same conservative majority, 6-3, I think probably the exact same justices who reined in agencies. Here's my crystal ball. In the Loper Bright our next term going to strike down a really important old case called Humphrey's Executor, which puts limits on the executive branch control over administrative agencies. Let that sink in for a bit. So those same conservative justices are going to enhance executive power. And Vic should worry about that for exactly the reasons he gave. These are fair weather folks who are making these judgments on Supreme Court. Sorry, that was two or three sentences.
No, thank you very much. Any other quick comments? There are a lot of deep issues raised there, separation of powers, but I want to get to a couple of questions that have been posted. One asks, so we have probably several non-lawyers in our midst. What are the practical implications of Loper Bright? Like, what do you foresee its effect to be on environmental regulations? Anyone want to take that?
I think it really, I mean, just again, very briefly, so much of that is bound up with the characteristics of the statutes that deal with environmental regulation. Just last week, the Supreme Court issued a decision unanimously in a case involving the National Environmental Policy Act, and sort of rolled back in some ways, and I think probably on the whole it was unanimous, sensible ways, the use of NEPA in imposing substantive requirements in the environmental area, and that was based on their reading of the statute. And they complained. The Supreme Court, interestingly enough, Justice Kavanaugh, in a majority opinion, complained that the courts had not given enough deference to administrative agencies in administering NEPA. So that suggests that there's a complexity in terms of the whole range of environmental laws that exist, both regulations and statutes, that make it a little unclear, I think, whether Loper Bright will have big implications on environmental regulation in one direction or the other.
So let me just piggyback on what Dan said. Dan earlier made the valid point that if courts are less reflexively deferential to the executive branch, and that was true under Biden, and if it remains true under President Trump, then President Trump may not be able to implement his agenda as smoothly and easily if the courts aren't giving him the benefit of the doubt at every turn. But I want to draw a distinction here, and I think it maps on to something Dan said earlier. I think when and Will did as well. I think if an administration is trying to undo something that an earlier administration did, I think the court feels that's different than if an administration is trying to do something that has never been done, that's new, that is using a statute in a way that where we don't have really any track record. So, for example, Friday's decision to effectively permit the administration to kill the CHNV parole program for 500,000 immigrants. I think the court's instinct on the merits there was pretty straightforward. As if, look, the statute doesn't say anything about this. This was kind of created by Biden out of thin cloth. And if Biden can create it, then Trump can uncreate it. And I think there's something kind of powerful about that reasoning. That certainly if there's no statutory direction either way, we're not going to say that a president can't pull back from what had been a very ambitious, adventurous action by a previous president. But I think what you're going to see that's different than, let's compare that to tariffs under the IEEPA, where we didn't really have, we're not talking about resurrecting a tariff policy that had been in place before or pulling back from it. We're talking about something new altogether. And there, I think, Loper Bright and the lack of deference and major questions doctrine and non-delegation doctrine will come back to bite the presidency and the administration. So I think it's hard to know in any particular regime which plaintiffs or defendants will be more successful. I think Will pointed out earlier, as a general matter, agency actions are going to be under more scrutiny, and agencies might lose a slightly higher percentage of the cases that are brought against them. But that's a pretty rough-grained answer to a question that really is going to be much more nuanced in the settings in which it arises.
Thank you. Will, any further thoughts?
Oh, no, just briefly, there was a lot of environmental and labor policy, quite frankly, that was decided or upheld on Chevron Step 2 which suggests that maybe as an issue area, environmental law would be more amenable to post-Loper type challenges. However, echoing what's already been said, it's going to depend on how the agencies react. So if the agencies take it as a signal to narrow the band from which they depart from their predecessors, or tighten the band, then it's not necessarily in judicial review where you'd see that effect. I mean, it's the actual policy. I mean, that is to say, the post-Loper effects don't necessarily have to be wrought in the Federal Reporter where they collect all the cases. God willing, it's the agencies get the message and temper their adventurism.
Will's point actually raises another really interesting issue. I mentioned at the outset that the court in Loper Bright was careful so as to leave in place, intact, all of the earlier rulings by courts itself and lower courts that had decided substantive questions using the Chevron framework. But it's like stare decisis. You never know when that past action is on all fours. So it may be that the court is not going to want itself or lower courts to really reopen any of those disputes, but whether those disputes should not be extended at all, even though logically they seem to suggest some ancillary resolution. But if the original case was decided under the Chevron framework, maybe it's going to be thus far and no farther kind of approach. But that's one of the unresolved questions: what we really, what it means to leave in place all those things. Just as stare decisis is a kind of a game for that's not for the faint-hearted.
Can I, Steve? I don't want to usurp the prerogative of the moderator, but there's a really interesting question in the Q&A that I wanted to maybe focus on. So so question was raised in a multi-part comment on the Q&A, which I recommend to you, about sort of the scope of regulation and its burdens and the administrative state. And let me use that maybe to create a civil disagreement with Will, maybe with regard to this. So there is and of course Vic in his presentation in chief talked about the kind of the anti-administrativism, the war on the administrative state. And what the commenter I think captures very well is when we talk about the administrative state, we're talking about something quite omnibus. Some administrative regulations, certainly over our expanse of history, are about the federal government sort of taking over the prerogative to do regulation. So the phrase "the nanny state," which used to be in vogue, right, as a way of sort of federal government saying we know what's best and we can engage in regulation to implement, social aims that are consistent, with the virtues that we signal from regulatory decision making that impose costs and shift costs on the American public. So that creates skepticism on the part of libertarians and others that worry about the expansion of federal authority. That's the administrative state. But so too is the administrative state, the incorporation, again, apropos of the commenter's comments, the dealing with externalities, where collective action problems make it difficult, if not impossible, for business to self-police and regulate. And so they impose costs that in the olden days, and the framers understood this, impose costs on individuals, the pollution that crosses over the yard, and we use the police power to deal with those. We use tort law. And of course, over the many decades, we used regulations to impose restrictions on externalities, and those shouldn't be something that libertarians and others should be at war against. And last but not least, there's aspects of regulation that are part of the federal government's largesse, the administration of our benefit programs, our veterans programs. So, at the risk of ranting about this, let me simply say the war on the administrative state sweeps in much too broadly all sorts of regulation that ought not to be anathema to those who want a thinner, weaker state. Some would be anathema, and some we should cherish, and we should really worry about anti-administrativism and the use of doctrines like the major questions doctrines and non-delegation or whatever as an omnibus war on the use of the federal government to do things that most Americans would think are important things for the federal government to do. And that is, I think, an unintended consequence of some of this worry about fear the deep statism that creeps into, sorry, Freudian slip, that creeps into much of the discussion in this area. Okay, off my soapbox.
Thank you, Professor Epstein. And following up on that, another audience member has asked or said, in my federal career, rulemaking gave Congress a chance to clarify the meaning of law. So I think she means, well, did Congress do that intentionally? And along with your comments, you just said, isn't that a good thing?
Shoot, I'll take a stab at it. Well, yeah, I'll note this. Congress does do that intentionally. So there are statutes where Congress says, we give interpretive authority over this term to the agency. Congress does so in a fairly in an identifiable way, impliedly. That is, without expressly stating it. And the Supreme Court, the majority, and Loper Bright noted some of the textual cues or clues, if you will, that indicate such an implied delegation of discretion. But I mean, the big kahuna on this is everything else, all the other ambiguities that don't really fit under either of those two categories. I do want to note one thing with respect to what Dan just said regarding regulation. And as I'm a swamp creature, so I've been in DC for 20 years, my entire white collar professional career, and I've witnessed how regulations get made. And just all too often, it is not the disinterested civil servant laboring away for the good of the whole. All too often, it's political appointees telling the civil servant what result they want pursuant to the Council of Economic Advisors in the Executive Office of the Presidency. So it's that element. We're at a world where everything we're done above board. Everything is done solely for altruistic benefit of Americans. Then yeah, the administrative state, even for this libertarian, would be a lot more palatable. But with my own eyes, I just don't. That is not how all the regulations that make the newspaper come about.
Great, thank you. All right, we have about 5 minutes left, so maybe a chance for one or two more questions. If audience members have a question, please put it in the Q&A box.
Let me, while we're waiting, can I just, I'm glad, Will, you mentioned about the implicit delegation point about Loper Bright, because that circles back actually to again, Vic's presentation about too soon to tell. The court, as we know, acknowledged that when Congress delegates this interpretive authority or leaves gaps unfilled, that administrative agencies may step in to fill those gaps under explicit delegations. They also said, we didn't talk about it much here, that while deference is not appropriate, some respect to the weight of authority under previous decisions, Skidmore and others, will still be maintained. So it's not the entire displacement of administrative agency action. So maybe an optimistic response to Vic's worry that I share, that we won't have, and Justice Kagan talks about powerfully in her dissent. What about AI? What about new technologies? What about areas of life where we need regulation? Not out of the noble efforts of the agencies, by the way, speaking of Will's comment, but because of the expertise and scientific expertise that agencies have. Maybe there's still room for that under the rubric of Loper Bright. I hope that's the case, and there's some reason for optimism, even in what the court said and didn't say.
Very good point. As much as I really want to get back into the separation of powers issue, I don't think we have time for that. And I think I should ask one question we had talked about in a previous session is, what is the effect on states and administrative law? States also have administrative agencies. What effect does Loper Bright have on them?
So I'll just quickly say, because Loper Bright is an interpretation of a federal statute, the Administrative Procedures Act, and by the way, it's been implicit in what we've said here, but even though Loper Bright has some constitutional separation of powers underpinnings, technically it was a statutory interpretation. That's one of the reasons why there wasn't as much kind of hand-wringing over the overturning of Chevron, because Chevron itself wasn't a constitutional decision. Even though it was a big decision, it was a statutory decision of sorts. And so revisiting the meaning of the Administrative Procedures Act and whether that act generally confers interpretive power to executive agencies in the absence of any more specific delegation by Congress. Loper Bright's answer, no, it does not. That doesn't mean that states can't have regimes whereby state agencies are given more power. The main constraint that the U.S. Constitution places on states is that they operate under a republican form of government. But I don't think that broad agency powers are violations of the Republican Guarantee Clause. So states can organize their governments in however they want. But I do think Loper Bright's going to come into play to the extent that federal regulatory agencies often interfaced with states. We see that a lot in the context of the Trump administration. The Trump administration is threatening to remove funding from California over transgender athlete policies. Well, where's the statutory warrant for the imposition of that condition on funding? The president says, well, I think I'm doing it because it's a reasonable interpretation of the statute. Well, we're going to get into some statutory interpretation, separation of powers issues in the context of a federal-state conflict. And so you're going to see a lot of these things play out in that kind of arena.
Great answer. Okay, one last audience question, and this is where I wanted to go anyway. So I'll ask each of you to just comment on that and use this opportunity for some closing remarks if you have any. We have a question: to what extent does the unitary executive doctrine come into play with these deliberations? So, Professor Marr?
Sure. So, I mean, Dan already mentioned that the Supreme Court has signaled, and it had signaled earlier as well, it has signaled that Humphrey's executor is going to be overruled or modified, and that the president is going to be given the power to remove members of the NLRB. But actually, that lifting of the DC Circuit stay in that case in the last week or two, what I found most arresting in that case was the completely gratuitous, almost irrelevant aside that a majority of the court made sure to include in there that says, by the way, none of this applies to the Fed, that the Fed is going to maintain its independence. So I do think we've been on a unitary executive kind of ride, and I think the Constitution generally does embrace a vision of the unitary executive. I do think the Fed is different for historical and structural reasons. But again, all the more reason why, if you have a president who's in charge of the whole administrative agency, you don't, as Will said earlier, you don't have kind of civic-minded individuals who are looking past the next election in the rules that they're promulgating. That, to me, I like the fact that, well, it's tied to elections and elections have consequences, but it does. It's one of the reasons why I'm not as worried as Dan is that the executive branch is going to be overly defanged.
All right, thank you.
Let me, my contribution, let me just say, and here I want to very much associate myself with a comment that Will made in the beginning of his presentation about Congress receding and really not exercising its constitutional prerogatives and indeed obligations to stand up, as it were, to all of this. If Congress were to, we would imagine a world in which Congress were to become more robust and to act again with some bipartisan interest in speaking on behalf as an institution to really engage in and provide the kinds of checks and balances that we agree are necessary, then we wouldn't lose sleep over the unitary executive ideas at all. We'd have a strong, robust executive branch, which I think the framers understood and welcomed. But the quid pro quo, as it were, was an independent judiciary, but also a very strong, active Congress that could actually get some things done. So the perils of the unitary executive, to me, are almost entirely the consequence of how strong both the courts and Congress are, particularly emphasizing Congress, the most dangerous branch, but also the most responsible branch for engaging in appropriate checks and balances.
And Steve, before Will jumps in there, because maybe he can respond to this as well, I'm not sure I fully understand why Congress has become such a lapdog, but I certainly don't have any sense that that's likely to change anytime soon. Whether it's the structure of primary elections or the like, But I don't, I agree with Dan that that would solve a lot of the problem, but I also worry that that solution is not forthcoming.
Will, you get the last word?
Oh, shoot. I'll just note very briefly regarding Congress. I suppose it's the death of the Northeastern conservative or Republican and the death of the Southern Democrat made the parties homogenized. And then also Newt Gingrich, the nationalization. Tip O'Neill says all politics are local. In '94, GOP changed that. Ever since then, all politics has been national. I think that's had an effect too. But my main point is, I thought that was a lot of fun. And thank you to Vic, thank you to Dan, thank you to Steve. That was great.
All right. Well, let's wrap up on that. Thank you. Thank you so much. Thanks for joining us. To our audience, thanks for our panelists, Professor Amar, Professor Rodriguez, and Mr. Yateman. Thank you. And I want to thank the sponsors of this series, the ABA, the Public Education Division. I want to thank the staff of the ABA who have been behind the scenes really putting this together. So thanks to them, and thanks to also Federalist Society, American Constitutional Society, Reform for Illinois, and everyone involved. Thank you so much. This has been a great discussion.